Welcome to WeLearn Virtual Learning Network. This is session number 12 of Personal Administration and topic is Administrative Tribunals. Topics to be covered are Administrative Tribunals evaluation, structure of tribunals, composition, jurisdiction, power and authority, procedure for application to the tribunals. Then last one is advantage and limitations of tribunals. Now evaluation. The growth of administrative tribunals both in developing and developing countries has been a significant phenomena of the 20th century. In India also, innumerable tribunals have been set up from time to time, both at the central and the state, covering various areas of activities like trade, industry, banking, taxation, etc. The question of establishment of administrative tribunals to provide speedy and inexpensive relief to the government employees relating to the grievances on recruitment and other conditions of service has been under the consideration of Government of India for a long time. Due to their heavy preoccupation, long pending and backlog of cases, cost involves and time factors, judicial courts could not offer the much needed remedy to the government servants in their disputes with the government. All dissatisfaction among the employees, irrespective of the class, category or group to which they belong, is the direct result of delay in their long pending cases or cases not attended to properly. A need arose to set up an institution which would help the dispensing prompt relief to harassed employees who perceive a sense of injustice and lack of fair play in dealing with their service grievances. This would motivate the employees better and raise their morale, which in turn would increase their productivity. The Administrative Reforms Commission recommend the setting up of civil service tribunals to function as the final appellate authority in respect of government orders influencing major penalties of dismissals, removal from service and reduction in rank. As early as 1969, a committee under the chairmanship of J.S. Shah had recommended that, having regard to the very large number of pending with petitions of the employees in regard to the service matters, an independent tribunals should be set up to exclusively deal with the service matters. The Supreme Court in 1980, while disposing of a batch of right petitions, observed that the public servants ought not to be driven to the force to dissipate their time and energy in the courtroom battles. The Civil Service Tribunal should be constituted which should be the final arbiter in resolving the controversies relating to conditions of service. The government also suggested that public servants might approach fact-finding administrative tribunals in the first instance in the interest of successful administration. The Constitution of India was amended to enable the setting up of civil service tribunals through 42nd and Amendment Article 323A. This Act empowered the Parliament to provide for adjudication or trial by administrative tribunals of disputes and complaints with respect of recruitment and condition of service of persons appointed to public service and post in connection with the affairs of the Union. Now, structure of tribunal. The Administrative Tribunal Act 1985 provides for the establishment of one central administrative tribunal and a state administrative tribunal for each state, like Haryana Administrative Tribunal, etc., and a joint administrative tribunal for two or more states. The Central Administrative Tribunal, with its principal bench at Delhi and other branches at Allahabad, Bombay, Calcutta and Madras, was established on 1st November 1985. The Act vested the Central Administrative Tribunals with jurisdiction, power and authority of the adjudication of disputes and complaints with respect to recruitment and service matter pertaining to the member of the All India Service and also any other civil service of the Union or holding a civil post under the Union or a post connected with defense or in the defense service being a post filled by civilians. 6 months bench of tribunal were set up by June 1986 at Ahmedabad, Hyderabad, Jodhpur, Patna, Calcutta, Jabalpur. The 15th bench was set up in 1988 in Ernakulam. The Act provides for setting up the state administrative tribunals to decide the service cases of the state government employees. There is a provision for setting up the joint administrative tribunals for 2 or more states. On receipt of specific request from the government of Orissa, Himachal Pradesh, Karnataka, Madhya Pradesh and Tamil Nadu, administrative tribunals have been set up to look into the service matters of concerned state government employees. A joint tribunal is also to be set up for the state of Arunachal Pradesh to function jointly with Guwahati bench of the Central Administrative Tribunal. Composition of the tribunal. Each tribunal should consist of a chairman, such number of vice chairmen and judicial and administrative members as an appropriate government may be fit. A bench shall consist of 1 jurisdiction member and 1 administrative member. The bench at New Delhi was designated the principal bench of the Central Administrative Tribunal, and for the State Administrative Tribunal, the place where their principals and other benches would sit in specified by the state government by notification. Qualification for appointment. In order to appointed as chairman or vice chairman, one has to be qualified to be judge of a high court or has held the post of secretary of the government of India for at least 2 years or an equivalent pay post either under the central or state government. To be judicial member, one has to be qualified to be a judge of a high court or has been member of Indian legal service and has held a post in grade 1 of that service for at least 3 years. Second is appointment. The chairman, vice chairman and every other member of Central Administrative Tribunal shall be appointed by the President, and in the case of state and joint administrative tribunals by the President after consultation with the governor of the concerned state, but no appointment can be made of the chairman, vice chairman or judicial member except after consultation with the Chief Justice of India. Terms of office. The chairman, vice chairman or other members shall hold office for the term of 5 years from the date on which he enters upon his office or until he attains the age of 65 in case of chairman or vice chairman. Second is 62 in case of any other member, whichever is earlier. Resignation or removal. The chairman, vice chairman or any other member of the administrative tribunal may, by notice in writing under his hand addressed to the President, resign his office but will continue to hold office until the expiry of 3 months from the date of receipt of notice or expiry of his terms of office or the date of joining by his successor, whichever is the earliest. They cannot be removed from office except by an order made by the President on the ground of proven misbehavior or incapacity after an inquiry has been made by the judge of the Supreme Court and after giving them a reasonable opportunity of being heard in respect of those charges. Eligibility for further employment. The chairman of the Central Administrative Tribunal shall be ineligible for further employment under either central or state government, but vice chairman of Central Tribunal will be eligible to be the chairman of that or any other state tribunal or vice chairman of any state or joint tribunals. The chairman of a state or joint tribunals will, however, be eligible for appointment as chair or vice chairman or any other member of the Central Tribunal or chairman of any other state or joint tribunal. The vice chairman of the state or joint tribunal can be the chairman of the state tribunal or chairman, vice chairman of the Central Tribunal or any other state or joint tribunal. A member of any tribunal shall be eligible for appointment as a chairman or vice chairman of such tribunal or chairman, vice chairman and other members of any other tribunal. Other than the appointments mentioned above, the vice chairman or a member of central or state tribunal and also the chairman of a state tribunal cannot be made eligible for any other employment either under the government of India or under the government of state. The chairman, vice chairman or other member shall not appear, act or plead before any tribunal of which he was the chairman. The chairman shall exercise such financial and administrative powers over the branches as are vested in him. Salaries and allowance and other terms and conditions of service including all retirement benefits in respect of chairman, vice chairman and member of the tribunal will be such as prescribed by the central government and cannot be varied to their disadvantage after appointment. Next is jurisdiction, power and authority. Section 14(1) of the Act vests the central administrative tribunals to exercise all the jurisdiction, power and authority exercisable by all the court except the Supreme Court of India under Article 136 of the Constitution. This relates no matter of recruitment, other service matters in respect of officers belonging to all India service or the member of civil service of the Union or those holding civil posts under the Union or defense service. No court in the country except the Supreme Court is entitled to exercise any jurisdiction or authority in matter of service disputes. The same authority has been vested in the state and joint administrative tribunals. One of the main features of Indian constitutions in judicial review, there is a hierarchy of court for the enforcement of legal and constitutional rights. One can appeal against the decision of one court to another, like from district court to the High Court and then finally to the Supreme Court. But there is no such hierarchy of administrative tribunals, and regarding adjudication of service matters, one would have a remedy only before one of the tribunals. This is in contrast to the French system of administrative courts, where there is a hierarchy of administrative courts and one can appeal from one administrative court to another. But in India, with regard of decisions of the tribunals, one cannot appeal to the appellate tribunals. The Supreme Court under Article 136 has jurisdiction over the decisions of the tribunals as a matter of right. No person can appeal to the Supreme Court. It is discretionary with the Supreme Court to grant or not to grant special leave to appeal. The administrative tribunals have the authority to issue rights in disposing of the cases. The tribunal observes the canons, principles and norms of neutral justice. The Act provides that a tribunal shall not be bound by the procedures laid down in the Code of Civil Procedures 1908, but shall be guided by the principles of natural justice. The tribunal shall have power to regulate its own procedures, including the fixing of the place and times of its inquiry and deciding whether to sit in public or private. Now, procedure for application to the tribunal. A person aggrieved by any other pertaining to any matter within the jurisdiction of the tribunal may make an application to it for redressal of grievance. The tribunal shall not ordinarily admit an application unless it is satisfied that the applicant has availed of all the remedies available to him under the relevant service rules. The tribunal may admit any application even after 1 year if the applicants can satisfy the tribunal that he or she had sufficient cause for not making the application within the normal stipulated time. Every application is decided by the tribunal on the examination of documents, written representation and at time depending on the case, on hearing of total arguments. The applicant may either appear in person or through a legal practitioner who will present the case before the tribunal. Now, advantage of tribunal. First one is appropriate and effective justice. The administrative tribunal are not only the most appropriate means of administrative justice but also effective means to providing fair justice to individuals. Flexibility. Principle of natural justice play an important role in the operation of tribunals. Less expensive. Justice by administrative tribunals is inexpensive in terms of cost involved. Relief of courts. The administrative tribunals have provided great relief to the judicial courts, which are preoccupied with so many petitions relating to civil, criminal and constitutional matters. Limitations. The administrative tribunals do not rely on uniform precedents, and hence this might lead to arbitrary and inconsistent decisions. There is no hierarchy of administrative tribunals, and this has completely excluded the scope of judicial review on service matters. The tribunal consists of administrative members and technical heads who may not possess any background of law or judicial work. The administrative tribunals, as discussed earlier, have the power to issue rights which till now was exercised only by the Supreme Court and High Courts under the constitutions. One more inadequacy noticeable in the present administrative tribunals is from structural functional angle. Now, there are some questions on the basis of this session. First one is, what are the different types of administrative tribunals? And second is, comment on the limitations of tribunals. That's it for this session. Thank you. Happy learning. We learning.